I'm going to talk about what happens, briefly, what happens during an audit, an income tax audit, and what are the taxpayers' appeal rights, both within the IRS and in the federal courts. And I made a little chart, and can I aim it a little better? Or no? Oh, never mind. I don't know how to do that part. Is that okay if I just move it? Well, I'll talk about while I'm moving it. So this is a chart. You can kind of see there's colors on it. So the top row is at the administrative level. And so that's, well, I guess I'm not going to go through the whole chart, but this will help you kind of follow what I'm doing. And then next level will be kind of the tax court, district court, and the court of federal claims, which are kind of trial level courts. And then there's the circuit courts and then the Supreme Court. So you kind of have an idea of how it all goes together. Okay, so let's begin with the examination of returns. And as you probably know, returns can be selected for a variety of reasons. It could be random selection, computer screening. There's a document matching program. That's, for example, in the W-2 and the 1099 or other information from a third party doesn't match the info reported by the taxpayer. And also related examinations, that would be when returns involve issues or transactions with other taxpayers, such as business partners or investors whose returns were selected for audit, and then they kind of catch on, and then they'll go after the other taxpayer too. All right. So the IRS audit, it's not the process to make everyone unhappy and miserable. It's the it's the IRS's process for examining a return to determine if it's correct. And there's 3 types of audits. There's the IRS office audit, where the taxpayer goes into the IRS office. There's a correspondence audit, which is done by mail. I think that's one of the more common ones. And then the field audit, which is when an IRS official will go out to the taxpayer's place of business. Actually, I have a lot of slides. Okay, so representation during audit. The taxpayer can act on his or her own behalf, and they could also be represented by federally authorized tax practitioner, which would be an attorney, CPA, enrolled agent, enrolled actuary. And I just put a little note that, if the taxpayer filed a joint return, then one or both of the spouses can meet with the IRS. They don't both have to go in there. Okay. All right, and then to act as the taxpayer's representative, you have to have proper written authorization from the taxpayer. And I'm sure many of you know this part, but it's the IRS Form 2848. And for married couples, you need 1 form per person. I think we used to use 1 form for both, but now you need 1 form per person, so that's changed. Makes it a little bit more of a pain to fill out, but you also want to be sure to attach the power of attorney of any existing power of attorneys that the taxpayer doesn't want revoked, because if you don't do that, it will get revoked. That's also an easy way to revoke a power of attorney, I suppose, if you just have an updated one. So if you are going to file one, make sure they don't already have a power of attorney on file with another CPA or an attorney that they want to keep. And there's a box you check for that, but you have to remember to attach it. All right, so I was briefly going to just mention, everyone's heard attorney-client privilege. That's, or I think everyone has heard of it, but might not know exactly what it protects. It protects communications, confidential communications between the lawyer and the client. And only an attorney can give the taxpayer this attorney-client privilege, meaning that the attorney is exempt from testifying against the taxpayer if the case goes to trial. And a CPA or a tax preparer, they could be made to testify against the taxpayer. All right, the attorney-client privilege is a common law privilege, so it's created not by statute, it's just created through courts, and it's been in existence for a long time. There's I'm going to call it, I guess I call it the tax advisor's privilege, or the tax practitioner client privilege, and that's a statutory privilege created by statute, and it's under 7525A1. And it's very narrow in scope, and you have to keep in mind that it's entirely inapplicable to criminal tax cases. And it's also, it applies only to the provision of tax advice. And so it doesn't cover non-tax advice. If you were going to do some general business advice or some sort of personal financial planning, if that doesn't fit in tax advice, it wouldn't be covered by this privilege. It also doesn't protect the tax practitioner's work product. And there's a special limitation that they added in where it doesn't apply to any written tax advice to a corporate type taxpayer concerning their corporation's involvement in a tax shelter. So that's not covered as well. Okay, so there's something called the Kovel Engagement, and maybe some of you've heard of this. It originated in an appellate court case, I think it's a 1961 case called United States versus Kovel. And it's a case where there was communications among an accountant, an attorney, and the ultimate client, who would be the attorney's client. And their communications, the accountant's communications, were protected from disclosure through an extension of the attorney-client privilege. And how it works is that the attorney will retain the non-legal professional, so it could be a CPA, it could be some other sort of expert also, to assist the attorney in rendering the legal advice to the attorney's client. And properly executed, a Kovel letter arrangement extends the attorney-client privilege to the CPA's work in communications. And so it can come in really very helpful. And it's just important to note that the attorney would be, say for example, you're the CPA and you've been retained by this attorney to help in a Kovel arrangement. The attorney is the client, not the ultimate client. So you'd want to address communications to the attorney. I mean, you could still write an email to the taxpayer, but you have to keep in mind that like if there's a memo is being addressed and advice, you're really trying to give that to the attorney so they can assist the client. In the Kovel case, compared the accountant to an interpreter. So you're kind of there to really just help the attorney, and that's why it fits under it creates an extension of the attorney-client privilege. Okay, so just some quick tips on the IRS audit. It's important to really keep good records and copies. Keep copies of everything you provide. Ask for an audit plan and timetable, and ask the IRS to submit their requests in writing, which maybe many of you have unfortunately had to see, really long IDR information document requests. Also, in your answers, be brief as you can. Don't volunteer info that's not requested. If you don't open a door, they can't walk in, so keep it shut. And don't give out your original documents, the taxpayer's original documents, to the auditor. Make sure you have a copy. If they lose it, then suddenly you have a really hard time proving a substantiation matter. So don't give out the original documents. Okay. A little bit of advice on preserving privileged or protected information in documents. If there is something that's privileged or protected, the taxpayer should decline to disclose the privileged material and instead submit something called a privilege log. And the log they're pretty simple. It would state the privilege or protection being claimed. For example, if I was doing, I could say attorney-client privilege is being claimed, or work product doctrine, but there could be some other privilege being claimed. And then you want to describe the material that, without revealing the information, allows the IRS or the court to assess the applicability of the claimed privilege or protection. All right, so say we've survived an audit and we're at the results stage of the audit. I break it up into 4 kinds. There's no change, refund, agreed, and disagreed. So in a no change, that's where the IRS accepts the return as filed and the taxpayer gets a no change letter stating the examiner proposed no changes. And I wrote, yay, because that's really good. And then there's refund, which is even better, That's like, wow, you get audited and you end up getting money back from the government with interest. I mean, that's pretty cool. So I wrote, woohoo, you know, yeah. I wasn't good at putting pictures, so I tried to use some exclamation marks. That first diagram took me like 3 hours to make, so read it with love, enjoy it. Okay, so, continuing on, now we're at an agreed audit. So I guess it's not so awful, you know, all right, they made some changes, taxpayer agrees, okay. So we're gonna agree them and then sign an agreement. I think you sign an agreement and then you just, if there's money owed, you pay it. Or if there's money owed and you can't pay it, there's lots of options besides paying in full. There's installment agreements and there's offers in compromise, which is where you try and pay a lesser amount of the amount owed because either you don't have the money or somehow you kind of convince them that you don't really think you're liable for it, but you just want to settle it and just pay it off. So it kind of makes it go away. Okay, and then there's disagreed. And disagreed is if did it go down? Yeah, if the IRS proposed changes and the taxpayer disagrees, and they disagree with the changes. So then when the audit ends disagreed, the IRS will issue a notice to the taxpayer called a 30-day letter. And that 30-day letter states the findings of the examiner. Sorry, I kind of use that interchangeably with auditor, even though there might be some technical differences there. But it states the findings of the examiner and the taxpayer's appeal rights. And you can note that this letter would also come if the taxpayer ignored the audit. So you could have a taxpayer come to you with the 30-day letter and maybe there wasn't ever an audit, nothing ever really was provided. So once you get this 30-day letter, actually, yeah, over there. Okay, it's a pre-assessment letter. So it's not an assessment letter. What this letter is doing is it's informing the taxpayer that a deficiency is being proposed, and it notifies the taxpayer to begin the appeal process within 30 days, the 30-day letter, or pay the tax. So to appeal the examiner's the examiner's proposed adjustments, the taxpayer would have 30 days within which to file an appeal. And when I have a case, it typically is a protest, a more formal appeal. So file a protest requesting a conference with the IRS Appeals Office to discuss and challenge what was disagreed in the audit. So if the taxpayer does nothing in response to that 30-day letter, then the IRS, unless they make a mistake, will issue a 90-day letter. It is always possible that they won't issue that letter in time, and the taxpayer could be very lucky. But I'm going to discuss the 90-day, call it NOPA. I call it stat notice. But also, note that since the 30-day letter, it's an administrative letter. It's not a statutory letter like the statutory notice of deficiency. The IRS, they might grant an extension, the taxpayer's request for an extension of time to reply to the 30-day letter. So it's not a hard, fast deadline. But if you miss it and they issue the notice of deficiency, you're kind of stuck at that stage in the process. So, okay. All right, so quickly on statute of limitations for assessment. The IRS typically gets 3 years from the date the return was filed to make an assessment. And I think I put that, yeah, Code Section 6501. And they get 6 years in the case of a substantial omission. And that's an omission of 25% or more of gross income stated in the return. And if there's an unfiled or fraudulent return, it's unlimited. They can just go after the taxpayer whenever they feel like it. And keep in mind, assuming there's a lot of CPAs in here, that you already would know the returns are typically, they're filed the following year. So when you think of it as 3 years, it's really 4 years in my mind, because it's, you don't file your 2014 return until 2015. So it'd be like 3 years from when it's filed. And that's just the typical. And there are a lot of there are some other ways that the government gets some more time, but Those are really special cases, like listed transactions, unreported type transactions. Okay. All right, so even though there is a statute of limitations on assessment for the government, the taxpayer and the IRS can agree to extend the assessment period. And my thought on this is that if there's only legal issues remaining in dispute, then it doesn't make much sense to extend the statute of limitations. And I'll go into that a little bit on my next slide. But if there's factual issues, like substantiation issues, then extending the statute of limitations might make sense. That way the taxpayer has time to gather docs and information. But if you're just fighting about the law, no matter how much information you give the government, it's not going to matter. So maybe it's better, in my opinion, not to extend and just move into the next process and hopefully get somebody that understands what you're trying to tell them better. So here's my tip for distinguishing between factual and legal issues. And to distinguish between a factual and legal issue, if you ask, how did I phrase it on there? Because I wonder if it's the same as what I wrote here. You want to ask where you must look to reach a conclusion. So you can say, where must I look to reach a conclusion? And if you consult only the law, and you're just going to look at the law, you already have all the facts, then the issue is legal. Otherwise, it's a factual issue that must be resolved through gathering additional information. So then it makes more sense to extend. Of course, if there's a lot of messy things you don't want them discovering in the return, maybe don't extend and try and move the process along. But if it's purely legal issues, it really doesn't make much sense to just keep arguing with the auditor. All right, if the taxpayer does not respond to the 30-day letter, or they're unable to reach an agreement with the appeals office following a protest, or the statute of limitations for assessment is about to expire, then the IRS will issue the taxpayer a statutory notice of deficiency, commonly referred to as a 90-day letter, or NOPA, or stat notice. Okay, I think of the statutory notice of deficiency as the ticket to tax court. One of my professors in law school called it that, and it's just kind of stuck with me. I was thinking it as, that's when you can go to tax court. You got your ticket and you go, and you don't want to miss your show, because if you miss your show, you can't go to tax court. So the ticket has an expiration of 90 days, but it could be 150 under there's special rule for 150 days. I think if the taxpayers, if it's mailed to the taxpayer outside the country, but most of the time, just think of it as 90 days. And the notice itself should say the last day to respond to it, which is by filing a petition in tax court. I think they're required by statute, the IRS, to put that date on there. So not only is it called a 90-day letter, it will have the date on there that you need to respond by. And this notice of deficiency, ticket to tax court, so it gives the taxpayer 90 days in which to petition the U.S. tax court to redetermine the liability that's been proposed by the IRS. And since this 90-day period is prescribed by statute, it cannot be extended. So it's not, the 30-day letter was at an administrative level, and you might not even get one. Sometimes they skip that letter, and they might go straight to the notice of deficiency also, because if they're too short on the statute of limitations, they're not going to do that stage of appeals. So, okay, during the 90-day period, the IRS is barred from making an assessment or collection activity. And if the taxpayer files a petition in tax court, this would continue until the U.S. tax court decision is final, or if you keep going up in the process to other courts. And so just very important to keep in mind, don't miss a statute. That's what we say, I guess, tax controversy to the attorneys. Don't miss the statute. Failure to file a timely petition with the tax court will result in the deficiency being assessed by the IRS. Okay, so now we've moved on to the courts. So it'd be the second row on my diagram that I did on slide 2. because the first stuff was really all administrative. I haven't talked about the refund claim, because we are jumping down now from notice sufficiency to tax court. Refund claim is if you keep going administrative, and then you go down to the district court or court of federal claims. So appeals to the federal courts is known as judicial review, and the taxpayer may request judicial review of the IRS determinations by filing a petition with the U.S. Tax Court, the appropriate U.S. District Court, or the U.S. Court of Federal Claims. And these courts are independent of the IRS. So you're now outside of the IRS administrative procedures. So the U.S. Tax Court is a federal court of limited jurisdiction. It was established by Congress under Article 1 of the U.S. Constitution. So if you remember back to your constitutional law, or I think we called it social studies when I was in high school, or when you learn about the Constitution and all that. So the tax court's not in the judiciary branch. It's a special court. So it's in Article 1. I think it's Congress. I didn't write it in my notes, so yeah, I think it's Congress. And the other courts are like a district court or Supreme Court. Those are all in the third branch of the. So it's a limited jurisdiction tax court. The jurisdiction included by statute for the tax court is redetermination of deficiencies in income, estate, and gift taxes, interest abatement cases, worker classification cases, collection due process cases, and innocent spouse relief. Okay, the U.S. Tax Court, it's located in D.C., and the judges, they travel around the country to designated cities to hear the cases. So here, the closest would be San Francisco. That's one of the cities they go to. And they go to San Diego and Los Angeles. And I think they just really want to go to San Diego because LA is pretty big, but they insist on going to San Diego too. But so I think those are the 3 places in California. Most of my cases were in San Diego because I was down there for a long time before I was up here. And yeah, the court there is very small, tax court. Okay, it's on that slide, but I'm just going to forward along. The tax court does not require the taxpayer to first pay the amount in dispute in order to file the suit. So that's a big reason why the tax court's a first choice for the taxpayer. So the reason why that 90-day letter is so important is because say your taxpayer gets a 90-day letter saying they owe $2 million in taxes. Well, they don't want to pay that $2 million in taxes right then. They want to fight the case. So what they do is they get to pay $60 filing fee to the tax court and file the petition in tax court for the redetermination of the IRS's proposed assessment. And then while it's in tax court, the taxpayer would be accruing interest. So if they did ultimately lose, there would be interest. So you have to keep that in mind as well. Okay. Well, that's where I was supposed to be. Okay. U.S. Tax Court, there's no jury trials. The case is tried before a single judge who has expertise in the federal tax law. And the tax court has its own rules and procedures that supplement the federal rules of civil procedure. In tax court, the IRS is represented by the IRS counsel out of the IRS's chief counsel office. And except for a S case, which I'll discuss later, small cases, the tax court decisions can be appealed to the appropriate circuit court. All right. So the U.S. Tax Court, I mentioned all the judges are in D.C. They travel the circuit is what they kind of call it. They just travel around, and then they go back to D.C. and write up their opinions and everything. But they come out to designated cities for the cases. Now these judges there's 19 regular judges, or there are 19. I think right now there's actually 18, but by statute there should be 19 because they're constantly retiring and adding new judges, and there's mandatory retirement ages. So these are the 19 regular judges. They're appointed by the president, and then they're after confirmation by the Senate, and they serve for a term of 15 years. And there tends to be a tradition of reappointing them after those 15 years. So unless they really don't want to keep being a judge. And then there's senior judges, which are the same presidentially appointed judges who have reached the mandatory retirement age of 70. And they're recalled by the chief judge to assist in disposition of cases. And special trial judges are equivalent to a magistrate judge in federal district courts. They serve at the discretion of the chief judge. And they tend to handle the small cases, or the S cases. Okay. All right. An advantage to the tax court route is that when a case is petitioned to the tax court, it'll generally be considered for settlement by an IRS appeals officer before the tax court hears the case. So this is really helpful because before you go through all kinds of discovery, you get the second bite at appeals, or maybe you didn't get the first bite at appeals because the statute of limitations was so close. So now you get a chance to try and resolve the case more informally with the IRS appeals officer. However, since this case is now on the tax court docket, it's a docketed appeal. So that means that any settlement would need to be approved by IRS counsel. And that can be hard sometimes if you have IRS counsel who's hot to trot to go to trial, as one of my appeals officers said to us in one of my cases, that she's hot to trot, you're not going to have much luck. So you have to keep that in mind. You have to have not just the appeals officer on board, but IRS attorney, possibly their supervisor, the chain. All right. This is something about the tax court. It's called the Golsen Rule. And the Golsen Rule basically says that the tax court is bound by the precedent of the circuit court in the I try to put this in non-lawyer language, so I'm going to read it. In the geographic jurisdiction or location in which the taxpayer is located. So I typically say that under Golsen, the tax court must follow the precedent of the circuit court to which the appeal would lie. But the other plain English, I think, except for the word jurisdiction, would be in the geographic jurisdiction in which the taxpayer is located. Thus, sometimes the tax court will reach different rulings for different taxpayers on the same facts. And I have a map that I found online. Okay. So, because I know whenever I talk about the circuits, I think people tend to know their circuit, like, oh, I'm in the 9th Circuit, but now you have a map of the circuits. So you can see why the 9th Circuit is, everybody says it's so random in its opinions, because you've got California, Alaska, and Hawaii all in the same circuit. It's just very different areas. They all have different interests. Oil, immigration, et cetera. So they just tend to be like, I think of it as like a swing circuit. Anyway, I was going to give an example, and that's on the slide before the picture, but I thought I'd show you the slide. So an example of how this Golsen Rule works is that, say there's a split in the circuit courts, and the 9th Circuit and the 10th Circuit have different rules. And then the taxpayer is domiciled in San Francisco, which is in the 9th Circuit. That would mean that the tax court would have to follow the law in the 9th Circuit. Even if the taxpayer decides to hold their case over in Florida, they would still be applying the law of the 9th Circuit. So you can't use the tax court to kind of shop around for the law. I mean, you're going to use the law the taxpayer has. And I guess with the business, you could do principal place of business. But you can't, you're pretty much, the court's going to be bound by that circuit. If there is precedent, there might not be precedent in that circuit, and then you can go to another one. But if there's a conflict in the circuits, they have to follow the one to which the appeal would lie. Oh, and this map also has district courts on it, if you're wondering what the little dashes are in California. So that's what those are. There's 4 district courts here. It breaks it down. Okay. Small cases. Those are the S cases. Those are for tax disputes involving $50,000 or less for any 1 year. And the taxpayers may elect to have a case designated as a small tax case. And these cases are heard by a special trial judge, and they are less formal procedure than regular cases. And what I view as a big disadvantage is that the decision in the S case is final, it's not appealable. After the S case, you're done. So have to keep that in mind. But it is less formal. I think it could be an advantage. I wouldn't see myself really seeking, personal level, I wouldn't see myself taking a case to that because the procedures don't really get in the way of what I'm doing, and I'm able to do the procedure and still focus on the case. But I could see how some taxpayers would take the case to that. But they are final, they're not appealable. Okay. All right, and this is also important, that the statutory notice deficiency, it has a presumption of correctness. So the taxpayer generally has burden of proving that the IRS's determination is improper. So this means, I mean, it's a little oversimplified, but if the taxpayer and the IRS, they go into court with nothing, the IRS wins. So you have to keep that in mind. The burden's on the taxpayer, generally. And the burden proof, it can shift to the IRS in limited situations. And also the burden of proof, it rests with the IRS as to any new matter, increases in deficiency, affirmative offenses raised in petitions such as statute of limitations, and fraud. And that one has a different burden of proof. It's by clear and convincing evidence, because fraud's a lot trickier for the government to prove. All right. In the U.S. tax court, the case is commenced by the filing of a timely petition. There's a $60 filing fee. And then you also would file a statement of taxpayer identification numbers, a request for place of trial, that's picking one of those designated cities, and for certain taxpayers, an ownership disclosure statement. And then be sure to raise any affirmative defenses in the petition if there are any, such as statute of limitations. Okay. All right, in tax court, after the petition, the IRS's answer to the petition, and if required, a reply by the taxpayer are filed. The case is considered at issue, and pretrial discovery can begin. However, this is typically where the IRS admin file for the case is sent back to the IRS Appeals Office to be considered for settlement. Again, settlement would need to be approved by IRS counsel. All right, the tax court rules, they permit the IRS to amend its answer when justice so requires, which in my experience is all the time. But keep that in mind. I had a case where they said, well, it's not like there was a summary judgment motion pending, and then we had a summary judgment motion pending, and they still were allowed to amend their answer to defeat our summary judgment, which meant we weren't able to get rid of the case on a procedural matter ground. We still had to go forward to the trial. And so it's applied very liberally. And another example I had was a case where the IRS, they amended their answer in a case to concede an NOL adjustment, and then they alleged a new $1.8 million adjustment based on an assignment of income theory about a month prior to trial, and they hit the taxpayer with an accuracy-related penalty. Like, they were inaccurate by $1.8 million, but I'm just saying they were allowed to do that because when justice so requires. So this is a little tip I think of, that if you get the notice of deficiency, the 90-day letter, and there's lots of messy and potential tax issues that are not raised in the stat notice, and assuming the taxpayer can afford to pay the amount of issue in the stat notice, it might be a good option to let the 90 days lapse of the stat notice so that the notice would become final, and then file a timely claim for refund that's limited to the adjustments in the stat notice. And this is a little bit more complicated than I'm making it sound, but timing is really important because otherwise the taxpayer might be able to bring in new tax issues. Pretty sure they can bring in new issues as I can't think of the word, an offset, because in a refund claim, I think they just need to support why you don't get the refund. But you might, because since they are able to amend their answer in court, it might be good to let the notice lapse so that you can try and limit the case to just what you want to fight about. But of course, this only works if the taxpayer has the money to pay the notice of deficiency amount, so they can file a claim for refund and sue for a refund. Okay. All right, so, and back to the minute answer, just to kind of sum it up, the burden of proof, if the IRS does amend their answer when justice so requires, the burden of proof on any new matter or increase in deficiency raised in the amended answer would fall on the IRS. Again, I think this is not as big a deal as it seems because the standard is pretty low. The standard of proof is pretty low. An example, I had a case with a bunch of Luna factors on partnership, whether something was really a partnership. And one of the years, the burden was on the government, and none of the factors were decided in our favor. They were either neutral or in the government's favor. But if, in my way of thinking is if the burden had shifted, well, they shouldn't have been neutral. If the burden had shifted to them, then we should have won in a neutral factor. So I just don't think it's that big of a standard. But that's just my perception of it. So, but they do get the burden of proof. Okay. The tax court rules, they reflect an abbreviated discovery process, a strong preference for a stipulation of facts and documents over testimony, and they have a desire to reduce the burdens and expenses associated with litigation in the other forums. And the tax court expects, basically, to sum up, they expect the parties to engage in informal discovery prior to using any formal discovery procedures. And this greatly reduces costs in litigation because I guess I also think of it in a tax case that quite often the facts can be completely in dispute. But in a tax case, I tend to think of it as, if you imagine like a case in court where, say not tax, but say somebody runs a red light. Well, in the tax case, we agree the light was red, but there's this reason why the taxpayer could go through it. And maybe in a say regular tort type litigation where it's like, someone hit my car and I'm fighting about the light. Well, maybe then you need somebody to decide whether or not the light really was red, whether it was green, whether it was yellow, And so the tax court, they really just want to get the facts out there so we can talk about the law and just kind of go forward. They don't want a whole bunch of arguing about the facts. So if there's any facts that can be agreed to, they expect the parties to agree to it, and you could be penalized if you don't. So, okay. All right, so I'm going to jump into the district court. So say you get the 90-day letter, and you either miss the deadline or you decide, or the taxpayer decides not to go to tax court, they want to go to one of the other judicial forms. So one of them is the US District Court, and the taxpayer can challenge the IRS determinations in a US District Court, but there's a procedural prerequisite, and it's very important. The taxpayer must first pay the disputed tax liability, and then file a claim for refund of the tax paid prior to filing the lawsuit. And I guess I'll keep it there. In district court, there's an option for a judge or a jury trial, unlike tax court where there's just a judge. And the district court is bound by the legal precedent in the geographic jurisdiction of the taxpayer. And then appeals are made to the circuit court in the geographic jurisdiction of the taxpayer. So again, with our San Francisco taxpayer, if they're in San Francisco, they would be bound, or the appeals would be made to the Ninth Circuit because San Francisco's in the Ninth Circuit. On there, it was in yellow, but I think it's just black and white on your slides. Okay. All right, a time for filing a refund. Time for filing the claim for refund. So generally, the taxpayer must file the claim within 3 years from the date the original return was filed, or 2 years from the date the tax was paid, whichever is later. And then I didn't put a heading up there, but so that's the claim. And then filing suit for the refund. So you generally have to file the suit for the refund no later than 2 years after the IRS has rejected the claim for refund. However, the taxpayer can file suit if it's been 6 months since the refund claim was filed and the IRS has not yet delivered a decision. So, okay, and then I guess I'll just briefly mention, this wasn't on, I think, the description I was going to talk about, but since it is one of the other judicial forms, I just included some slides on the U.S. Court of Federal Claims, and that's a court of limited jurisdiction created under Article 1 of the Constitution, similar to the tax court, and they don't have jury trials, there's a judge. And just like the district court, the taxpayer has to first pay the disputed tax liability and file a claim for refund of the tax paid prior to filing the lawsuit. And another thing unique about the U.S. Court of Federal Claims is that appeals go to the Federal Circuit. So actually on the circuit map, like pointing to it, but it's not there, there were 11 numbered circuits, but there was also a DC circuit, and there was also a Federal Circuit. And so the appeals from the Court of Claims go to the Federal Circuit. And the Court of Federal Claims, it's bound by precedent, so the law, the rules of the former Court of Claims, the Federal Circuit, and the U.S. Supreme Court. And I guess the last thing would be there's a limitation with the U.S. Court of Federal Claims. The taxpayer can't file a suit in the Court of Federal Claims if the taxpayer's claim is for a credit or a refund of a penalty that relates to promoting an abusive tax shelter or aiding and abetting the understatement of tax liability on someone else's return. So that's a limitation with the Court of Federal Claims, not the district court. Okay, I think that's all I've got. Yeah, okay. So that's the end of what I've prepared. I don't know if you want any questions or not.
The one in the back here.
Hi. I have a client who missed the, he came to me really late, missed the 90-day filing. So it's like 2 years Schedule C, he owes like 10 grand, it's like a penalty of a couple thousand. Can you file an amended return? Can you do anything, or is he just completely out of luck and just tell him to pay up?
I think I need more facts on that because, well, I'd have to know also when the notice was sent, because sometimes the notice is sent at the very end of the statute of limitations, but sometimes it's not. So if it would be, sorry, it's hard to answer that. I'm trying to think.
So it was sent like March 31, so pretty much June 30th of this year. It was, you know,
and what tax year would it be?
This would be tax year 2012 and 23.
Oh, so it's really hard math now. I have to do like, this is why I like CPAs. They do my math for me.
File an amended return after they've kind of shut the door on the audit?
Well, what you'd be doing, why would you file an amended return to try and, oh, that's why.
To substantiate, maybe to try and put on more or different expenses, or lower the revenue.
So that would be.
Open the case, because now it's just going to pay off.
Well, that's when you'd want to look, I think, at, yeah, the time for filing the refund claim. So that's why I was wondering about the years, because it sounds like what.
They're within the statute. That's your question.
Can you do that after they've already made
You did the math.
on an audit, though? You still file an amended return?
Well, the audit is.
So the facts are that you got the 90-day letter, you ignored it, 90 days on hand, so you can't go to tax court. So now you have to go to district court and pay the tax and sue for a refund. And you want to know if you could file an amended return and claim some additional deductions, as long as you're going all that trouble.
Right.
Pretty much. I'm pretty sure the answer is yes.
Assuming the math is right.
Yeah.
I'm trusting your math, but
within
because you'd want to, because what you'd want to do is, yeah, see, so the claim for a refund, you can file it with that form. Say it's 826, 836. There's a form, but you also do a claim for refund by filing an amended return, also. But I think it would still be. You wouldn't amend the return. I think you would do the administrative claim for refund. I think.
But that's how you claim it.
But yeah, but I think there would be a procedure for it. It's just I'd have to think about it more. You're welcome to contact me after this with your question. But yeah, and there's also other alternatives. There's collection alternatives and other things to deal with too, like offers and compromise and data's liability, all that. But yeah, you just can't go to tax court.
Just can't go to tax court. Any other questions? We're going to take a short break. One here.
I'm sorry. Is the tax court process a little more streamlined? Is that why is there a benefit to not paying going to tax court rather than paying going to district court?
Well, most people, at least in this economy, haven't been able to pay, because usually they get in trouble for something that like a long time ago, and now like all their, I mean, it's getting better, but a lot of people just don't have the money to pay it. So, I mean, imagine getting a bill in the mail for, you know, even $50,000. That's like a big bill. So, But yes, it is more streamlined. I think there's the advantage of getting the second bite at appeals. That's an advantage. Reduced discovery. When you're in the district court, I didn't mention it, you're up against the DOJ attorneys. They're a lot more formal.
Lauren, let's pause
yeah,
on that.
sorry.
That's a really good point. That second bite at appeals. So
I had 2 slides on that.
Once you go into tax court, they kick it back to appeals, right?
Yeah, that's why I had 2 slides in there. But it is a docketed appeal, so you have to keep that in mind. But that's like, a lot of times people try to file that petition because they're still hoping to do appeals. And that's, I think, where you hear of cases where maybe a CPA wants a lawyer to kind of babysit the case while they try and negotiate a settlement. They're basically just filing the petition for the purpose of just going to appeals. But doing that, be careful, because while you're in tax court, there are things that can happen. Once informal discovery is passed, they could start issuing formal discovery. And if while you're trying to negotiate with appeals, the IRS counsel is sending you requests for admissions that are not responded to, suddenly you'll have deemed admissions and the case could be lost. So even though you are in appeals, you still have to keep your focus on the court case. So you don't want to just file in court hoping to go to appeals and ignore all the IRS attorney's requests, because it's good to really know what's going on in tax court or have an attorney with you on the case a bit.
So it's a strategy, you just have to be careful.
But yeah, and you get the judge who's an expert in tax law. I mean, if you were to read some of there was like a great article on the Supreme Court trying to talk about TEFRA, which is partnership proceedings, and all the judges were asking questions, and it was just, when you read it, you just imagine the judges being like, so in TEFRA, and they just sounded so confused, like, I don't get it, I'm confused, and it's like quotes, and it's a really great article, and that's our Supreme Court justices talking about TEFRA. So it's an article on the Woods case. It's hilarious.
You're saying that tax court judges tend to be smarter about tax.
Yeah, I mean, they're specialized in it. They're specialized in federal tax law. When you go to district court, they've got immigration cases, they got drug cases. I mean, they got all kinds of other things. And there's like one tax case on their calendar, and like, oh, a tax case, huh? You know, it's just kind of weird. Like, what do I do here? And then what do? They focus on the facts. And in tax court, we're focusing usually on the law, unless it's a substantiation case. And so they'll get hooked on some little fact, and the judge is just gonna, it'd be more streamlined, and it's a lot. I think it's a better procedure.
All right, one more question.
Form.
If your client is selected for audit because of a related examination outside partnership and TEFRA, how much can the IRS use from that related examination? The documentation, anything or nothing?
That's interesting. I just had a conversation about this, but we didn't disagree. We didn't agree. This was yesterday. So, so I don't know off the top of my head how much they can use. I mean, I guess you mean in the actual court case, or just in the, because in the, well, I guess it depends on the relationship between the taxpayers. Like, was it a partnership?
You would request all the same things, and then you have to give it to them.
Yeah.
And get it directly anyway.
Yeah, they can clearly do that.
There might be some things. That's like I think a lot of the things about tax litigation is a lot of it's case specific. So I would really need more facts, but trying to think that there might be ways to keep some things out, but it really depends on the relationships with the taxpayers. And also, if the information is something that's going to help the taxpayer, then maybe it would be good to have that in. Like, I don't know, was it a partnership and now you have the partner? Because then it would all be, I think then they would probably have access, but because in the larger TEFRA cases, then they basically try and do everything at the partnership level, and then they trickle it down to the partners. I've actually had mostly just those types of cases with the TEFRA audit rules. So I suppose those rules were created because things were inconsistent at the other cases. So there might be ways to keep stuff out. And there might be some other privilege or way to keep it out. Maybe it fits under some other work product or some other privilege.